Winning 1 million is one thing. Winning 10 is another. Winning 100 million on the first day of the year, well, we wish him all the best with that. Now, let's talk about the focus on 2017 now. The High Court will, on the 9th of this month, hear a petition seeking to block President Uhuru Kenyatta from assenting to any changes made by Parliament to the Electoral Laws Amendment Act. Tonight on Spotlight 2017, our reporter Murimi Mwangi interrogates the role of courts in safeguarding the sanctity of the electoral process and the possible impact of that on the image of the Supreme Court should any presidential petition be filed there in 2017.
For the past 5 years, the Kenyan judiciary has faced a rough time from Parliament and even the executive over some constitutional decisions. A standoff which now appears to have been reignited by the ongoing debate in Parliament over changes to the electoral laws and court cases opposed to the same ahead of the 2017 polls.
Executive roles cannot be curtailed by the judiciary. Neither can judiciary become a squatter in the periphery of the legislature.
In a democracy, particularly where the Constitution itself says that we are a constitutional democracy, there is no better referee and repository of the rights and freedoms of the people than the courts. But if you look at
On 9th January, the High Court will hear an application in which the opposition coalition CORD wants President Uhuru Kenyatta blocked from assenting to any changes to the Electoral Laws Amendment Act. High Court Judge George Odunga recently came under direct attack from National Assembly Majority Leader Aden Duale, an attack which Attorney General Githu Muigai argues was uncalled for.
24th of January, when we come back, I will introduce a motion to discuss you. That is a provision. We will discuss you and we will expose you. You cannot be a member of the bench and play tribal politics.
And we are entitled to disagree. We must moderate the language we use to address judges. It is inappropriate that a judge should be the subject of political commentary.
It is also not lost on us.
But as the senators finalize debate on the controversial changes to the Electoral Laws Amendment Act on Thursday, the Office of the Attorney General and lawyers representing speakers of the National Assembly and the Senate will be dusting their notes as CORD formally argues its case at the High Court on 9th January. This as it emerged that the government never consulted the Attorney General before drafting the contentious amendments.
It was wholly and exclusively a political process centered in Parliament. Indeed, the politicians themselves agreed not to make any alterations whatsoever.
The current standoff has been sparked off by Jubilee, which wants the IEBC to revert to manual voter identification and transmission of results in the event that technology fails.
in Kenya, there is established an electronic electoral system, integrated electronic electoral system. So that if you are going to talk about backup, that backup, by definition of the law, should be electronic.
We must be able to separate the difference between technical issues and political issues. Because if we handle these things together, if we politicians make technical decisions, then clearly we are likely to have a bad decision.
It cannot be business as usual, where a player in the game is the one setting the rules. Because all these amendments that we're arguing about and resisting are creations of the Jubilee regime.
Honorable Raila Amolo Odinga was almost denied the chance of voting when his name was not found in the Langata constituency Electoral Commission register. But Mr. Speaker, there was a backup. The then Electoral Commission had a backup, which was called the Black Book Backup, which had the name of the former Prime Minister. And in the process, Mr. Speaker, he was allowed to vote.
But as the electoral debate and the court battles proceed, analysts argue that court decisions relating to the 2017 polls at the High Court and the Court of Appeal will have a great impact on the credibility of the judiciary, and by extension, the Supreme Court, ahead of the August 8th general election.
People are very excited about the Supreme Court, and it just took one case, the presidential petition that was filed in 2013, to create a position where people began to ask questions about the independence of the Supreme Court.
As the judiciary continues fighting for its independence, the friction between the courts and the political class will be a key development to watch, as it will have a great impact on the public perception regarding the Supreme Court as the 2017 elections approach. Murimi Mwangi, KTN News in Nairobi.